Today, the potentiality of litigation in the workplace is real. It seems that we are all too happy and are looking for someone to correct the wrongs that happen to us as an individual. Therefore, we need to be aware of our risk of being sued because if we provide care that is not correct or outside of our scope of practice, there could be legal ramifications. In this first section, we are going to look at a variety of legal terms so that you have a firm foundation of what they are and how to defend against them. First and foremost, we need to define negligence. Negligence is a term that means that a person did not act as a reasonable, sensible, or prudent person would. This is part of tort law. A tort is not a criminal act against someone, but a civil wrong that occurs to someone's body or property caused by another person. In tort law, negligence is unintentional harm. Therefore, when we look at this part of tort law, for someone to be found negligent, the injured person has the burden of proving that the defendant did not provide care to the plaintiff or the injured person as any other reasonable person would. In order to do so, they have to look at 4 components of negligence. The first is a duty existed by the defendant to the plaintiff. Number 2, the defendant failed to perform the duty. Third, the defendant failing to perform the duty was the actual cause of the plaintiff's injury or illness. And lastly, number 4, injury or illness occurred to the athlete. When an athlete can claim negligence, they are typically in harm or have some sort of injury. However, for this claim to go forward in court, the defendant or the injured person has to have a duty, that the defendant has to have a duty to the athlete. In other words, the defendant was liable and responsible for the athlete's well-being and had a special relationship with the athlete at the time of injury. If the plaintiff cannot prove this, that the defendant had a duty to them, negligence cannot be proven and the case would be dismissed in court. Part of this idea of proving that they had a duty is standard of care. When a defendant has been charged with negligence, it has to be shown that the defendant not only had a duty to care for the plaintiff, but also did not meet the expected standard of care. Standard of care is referred to as the manner in which the defendant acted compared to other defendants with similar qualifications. If we fail to act in the standard of care or in the care or we overstep our boundaries, we have this idea of failure to act, and this is the second step in proving that the person is found negligent. There are multiple ways that a person can fail to act. Failure exists if the defendant participated in an act of omission. Omission, also called nonfeasance, is when a person does not perform an act that he or she is qualified to do. Misfeasance occurs when a person is legally able to perform an act that he or she is qualified to do, but performs the act improperly or incorrectly. Lastly, a failure exists in commission, also called malfeasance, and this occurs when a person performs an act that he or she is not qualified to perform on another person. The biggest part to negligent claims is that the defendant has to prove that the plaintiff has the burden of showing that that person was directly injured based off their actions. So in order to prove negligence, the plaintiff has the burden of showing that the defendant's failure to act in a reasonable manner is the primary cause for the plaintiff's injury or illness. This is typically very difficult to prove. The athlete or the plaintiff must also prove that that actual harm resulted. Not that harm resulted and then they got over it or they got better after it, but actual harm or damages occurred for a long term. Another common term that we typically see is foreseeability. Even though that we have this special relationship between two people, we do our best to provide treatment and foresee things that can go wrong. Foreseeability is the ability of a person to anticipate this danger and the resultant harm that could occur to others sharing in this relationship. However, even when we conduct ourselves in a very professional manner and a reasonable manner, an unforeseeable act can cause harm to another person. When an act is not foreseeable, then the person who performed the act cannot be found to be negligent. However, if we are found to be negligent, there's also what we call comparable fault. Comparable fault, also called comparable negligence, can exist if fault in a negligent case is deemed by the court that both the defendant and the plaintiff is at fault. In these types of cases, the court typically assigns blame to both the defendant and the plaintiff as a percentage of total faults. The court determines how much the plaintiff contributed to the negligence. Most states have adopted this principle of comparable fault. However, in the past, states have utilized contributory negligence. Similar to comparable fault, contributory negligence is found when a plaintiff is deemed to be responsible to some extent for the injury. The major difference, though, is how the compensation is awarded. Unlike comparable fault, if contributory negligence is found, with the plaintiff contributing to the injury to any extent, then no compensation will be awarded to the plaintiff. Comparable fault can also be seen in vicarious liability. This idea of vicarious liability, also called respondeat superior, is when an employer is responsible for its employees' negligent acts. This doctrine is imposed only if the employee was working in his or her employment capacity under the employer's direction. So it has to be directly under that employer for this to occur. Therefore, if the employee is found to be negligent and they are acting or working under the direction of the employer can also be found negligent in this case. Something that we commonly see is assumption of risk. In many athletic activities, due to the inherent nature of the activity, some sort of risk is possible. Assumption of risk is when a person knowingly recognizes the inherent risk of an injury when they participate in that activity, but they choose to participate in that activity anyways voluntarily. This is very common in sports, but regardless, most athletes understand that by the activity's nature, injury can result. In order to participate in activity, the athletes voluntarily accept this risk. There are two different types of assumption of risk. Implied assumption of risk is when an athlete assumes that the inherent danger associated with an activity. Express assumption of risk is when the participant recognizes the potential for harm and signs a waiver relieving the organization from any liability for incurred injury. In most traditional athletic activities, implied assumption of risk is very prevalent and is what we typically see. Attached to assumption of risk, specifically express assumption of risk, even though the athlete knows and voluntarily participates, even though there is inherent danger, they typically sign a waiver to show that they understand these risks. This is an example of a basic waiver. A waiver is a type of contract presented to an athlete by an organizing body with which the athlete participates. Once the athlete signs the waiver, the organization is released from any liability if the athlete is injured. This is typically seen with summer camps or athletic summer camps or sport camps. We also have the term of Good Samaritan laws. Good Samaritan laws are commonly seen within healthcare, and these are laws that are actually statutes that protect someone from legal liability when they are assisting an injured or ill person. These laws are often considered first aid immunity, and even though they are different among states, they generally provide some protection for people for providing necessary first aid in emergency and life-threatening situations. Lastly is the term of statute of limitations. When an injured person decides to file a negligent claim against another person, they do not have an unlimited amount of time to file a lawsuit. The statute of limitations is a finite number of years in which a person can file a negligence claim. This is determined and varies by state, but in most states, the statute of limitations is from 1 to 4 years. The only exception to this is when the damages occurred to a minor. In this case, the statute of limitation begins when the child turns 18 years old. Therefore, even if a minor or a child is injured at 13 or 14, they still have until 1 to 4 years after the child turns 18 years old to file a negligence claim against another person.